right. Good morning, everyone. So, as promised, this second live video from this morning is simply to um, give you guys all an understanding and explanation of comparing the different petitions that are out there. As far as I know, ours is actually the only one that's circulating right now, and the other two, or possibly three, are going to be circulating starting in the first week of July. So, we have a constitutional amendment petition. The Restore Freedom Initiative is a proposed amendment to change certain parts of the Constitution to restore freedom to where it started, where our founders envisioned it in the U.S. and then the Michigan constitutions. So that is what ours is. And so ours, when we get enough signatures, what it's going to do is put us on the ballot for November 3rd, 2020, on the general election ballot. It's not a constitutional convention. It doesn't open up the whole state constitution. It's it's not a general revision. You would literally be voting yes or no to accept this amendment. Just like in 2018 when we had, I think, three on the ballot, and one was the Voters Not Politicians piece that added 4,250 words to our state constitution. We didn't have all of those words on the ballot. What we had was the little summary. I believe it's the 100-word summary that you'll see that is voting yes or no on. So, all right. So that's what ours is. And so ours, when it gets on the ballot in November, then when we get a simple majority of voters to vote it through in November, 45 days after that, which I believe I calculated to be December 18th, that's when those changes would be enacted or come into effect. And it's not changing statutes, it's changing the Constitution. However, there are many statutes that would be affected by the constitutional amendment change. So, to the extent that those statutes no longer comply with our Constitution, with those new amendments, those statutes are not going to be enforceable. So, even if the legislature doesn't go into session to remove them from the books, so to speak, they're not, they're not enforceable at that point. So that is, in a nutshell, what ours is doing. Okay, it's modifying the current state constitution very specifically with a yes or no question on the ballot. So the next one I wanted to mention is the recall petition. Okay, currently there's only one approved recall petition, and that is with I don't know if I'm going to pronounce his last name right, but Chad Bosse. That is his group. I want to say their official name is Committee to Recall Gretchen Whitmer. And so they are starting to circulate, I believe, July 1st. I know they're going to have some big kickoff July 4th, I believe, at the Capitol. But they're circulating the petition simply to recall the governor. And just to be clear, when you recall the governor in Michigan, it's different than any other public office where you're doing a recall. So instead of there being an election where you have two people that are, let's say we got enough signatures for the recall and there's going to be an election. Normally you would think, okay, so Gretchen Whitmer is going to be on the ballot and then anybody else can run against her. That's not how it's going to work. With a governor, the state constitution, Article 5, Section 26, specifically requires that whether she's recalled, she dies while she's in office, she resigns, she is convicted through the impeachment process, or she's removed from office from any other way. Once she's removed, then it goes to the next in line, which is the Lieutenant Governor Gilchrist. He would become governor. If he is recalled or resigns or whatever, it would go to the Secretary of State. If she is unavailable, resigns, recalled, then it would go to the Attorney General Dana Nessel. If she is unavailable, then statute picks up. And so there are state statutes that then say it would go to Mike Shirkey as the Senate Majority Leader, and if he's not available or if he's recalled, then it would go to Lee Chatfield as Speaker of the House. So that's the succession of governor. It's totally different. So there will be an election, but the election will say, let's see, what is the language? Should Gretchen Whitmer be recalled from the office of governor? Yes or no? That's what you'd be choosing. You're not choosing between two different people or three different people. You're choosing, should Gretchen Whitmer be removed? Yes or no? So if the recall petitions gain enough signatures by the required time frame, that's the question that'll show up on the ballot. Okay. So there's also an additional recall petition, I believe, for the governor that is in the pending stages with the Board of State Canvassers. And so we may very well have two, possibly three, but I think two Gretchen Whitmer recall circulation, petitions being circulated. If that's the case, it is okay for you to sign both of them. Just make sure you only sign each one once. Be very careful about that. So, same thing is actually true for our petition. You can sign our petition and sign one of the recall or both of the recall petitions. That's okay. There's no law or rule that says you can't sign each of those. And I don't know to what extent they're going to be able to work something out, but I had been suggesting to the two recall groups, which I'm not a part of, that they should try to work together, because if they can each go out and obtain signatures, then if somehow one of the recall petitions gets challenged successfully in court later on, if they have the signatures required under the other petition, either way they're good to go. Just because the language made it through the Board of State Canvassers does not mean that there's not going to be some sort of other organization or entity challenging the language or the petitions themselves in court. So, okay, so all that does is remove the governor. Recall petition is removing the governor, period. That's all it does. So if Gilchrist ends up taking her place or whoever does that, if they're going to do the same things, then there's nothing to stop them anymore than what's going on right now. So just keep that in mind. I'm not saying you shouldn't pursue recalling Gretchen Whitmer. Many of you understand that it's not going to fix the overall problem. It's just one piece of the puzzle to make sure that she's personally held accountable and not able to benefit from receiving a big state paycheck from us when she doesn't have our best interests at heart. So, okay, so then third is a petition to repeal the 1945 Emergency Powers of Governor Act. They have some schmancy name for that. What is that? I don't know. I can't remember. But their petition, what it's going to do is, my understanding is the route that they're taking is they're trying to get enough signatures, not so that it would end up on a ballot. They're trying to go the route of gaining enough signatures on their petition so that they can then turn all those signatures into the legislature, and the legislature would then vote on whether or not to do what the petition was asking, which is to repeal the 1945 Act. So if that happens and they get a simple majority of the legislature to vote to do that, then they're not subject to the governor vetoing the bill at that point. So it's still not a guaranteed thing, though, because you still have to have enough votes from the legislature to support that. Okay, so the differences with that is the 1945 Act by itself, I don't think is terrible. It's not perfect. There's problems with it, but I don't think it's so terrible in and of itself that it needs to be repealed. Certainly, it cannot be read alone. It has to be read in conjunction with the other statutes on point. That's a given. But and at any rate, that's my own thought. Do I think it's going to harm anything by people signing the 1945 petition? No. So I'm not going to tell you not to sign it. I want to say I didn't see his video personally, but I had many people that saw Ron's video through, the Stand Up Michigan effort, the repealing the 1945 Act. My understanding is what he was saying is getting the 1945 petition through would be like getting a base hit, right? So you get to first base. But getting the constitutional amendment petition passed through and onto the ballot and voted on by the people in November would be the grand slam. So if that's truly what was, what he said, like I said, I didn't see him myself, but if that's truly what he said, I would agree to some degree. Like this is the whole big package. The one that I wrote, the constitutional amendment petition, is the whole big package. That's the one to make sure this never happens again. Okay? But the petition to repeal the 1945 Act does not do that. It's not going to make sure that this never happens again. As we know, the governor has referred to her petition, her executive orders, her powers, these emergency powers, as stemming from both the 1945 Act and the 1976 Emergency Management Act. And I wanted to share with you guys. Okay. Just put this into context. Let's see here. I just thought of this, but I wanted to share this with you while we were discussing this. Okay. So, let's look at the fact that on April 4th, Speaker of the House Lee Chatfield wrote in a letter to the House Minority Leader that since 1977, there have been 35 states of emergency and 52 states of disaster declared by the governor's office. So basically, after the passage of the Emergency Management Act, before Gretchen Whitmer and the current go-round of states of emergency, 35 states of emergency, 52 states of disaster were declared by the governor's office. In total, 4 states of emergency and 6 states of disaster were extended by the legislature. None of them were emergencies or disasters that were extended unilaterally by the governor, which reflects the 28-day time limit written into the law. So I want to expand on that. So those were the words of Lee Chatfield on April 4th. However, I would say that the whole history of executive orders paints a very consistent picture too. Hang in there with me. This goes to the point of how the 1945 Repeal Act is not the same as our constitutional amendment, and how it could solve one little piece of the puzzle, but I'm trying to explain how all those pieces connect. Okay? So between 1993 and 2019, all the way through 2019, there were 605 executive orders issued by Michigan governors. I found it interesting that of all of those, a vast majority, I want to say like 85% or 90% of them, were written by the Democrat governors, not our Republican governors. Not that our Republican governors don't write them, but they would write, 6 or 10 in a year, if that, whereas the Democrat governors have been writing many, many more in a given year. But they're not emergency orders. They're not emergency power executive orders, okay? So, there were 605 executive orders issued by Michigan governors between 1993 and 2019. You can find this information right on the Michigan legislature website. If you go all the way to the left, they have that column where you could do a basic MCL search or an advanced search. You can look at the chapters of Michigan laws, the Michigan Constitution. There's also a button to see executive orders. And they only go back to 1993. So, of those 605 executive orders, 25 of them were based on a governor's emergency powers, okay? So, all the other ones were basically restructuring the executive branch, moving around people from, one commission to another or whatever, but they were not things that directly impacted the lives of Michiganders, okay? They were executive orders that dealt with Article 5, Section 2 of our state constitution, where the governor is just reorganizing something within her own executive branch. So 25 of them, though, were emergency power executive orders. And in each of those 25, between 1993 and 2019, all the way through 2019, in each of those 25 executive orders, the Emergency Management Act of 1976 was actually the sole authority listed by the governor at the time as the exercise for those emergency powers. Not the emergency power, or Emergency Powers of Governor Act of 1945. The Emergency Management Act of 1976 was the sole authority for emergency powers cited by the governors between 1993 and 2019 to be using these emergency powers. Okay? So, to that extent, repealing the 1945 Emergency Powers of Governor Act would not change a single thing with any executive order that has been issued between 1993 and 2019. In fact, only one of these orders between all those years, one of the orders even referenced the Emergency Powers of Governor Act of 1945. None of them relied on it as a statutory authority, and only one of them even referenced it as even being relevant to declaring these states of emergency or states of disaster. So, in all of them, except for one, the 28-day time limit that's found in the 1976 law was recognized. In all but one, every single governor recognized right in the language of the order that the order expires within that 28 days. The only one that didn't have a deadline in terms of a specific date was the one where I want to say there was an explosion on I-75 and the state of emergency was declared just for the repairing of the freeway. And so it was going to last only so long as it was needed to repair I-75. There was no shutdown of businesses or homes or quarantining people or denying medical care for non-essential services or anything like that. It was just a state of emergency to fix I-75. So, of all of these executive orders referencing the Emergency Management Act as the only source of power, for the only source of emergency power authority, and expressly recognizing the 28-day time limit, 7 of these were written by Governor Whitmer herself in 2019. 7 of these orders that I've been talking about were all the executive orders that have been based on emergency powers have been written anytime since 1993 through 2019. Of all of them, 7 were written by Governor Whitmer herself, acknowledging the 28-day time limit involved, and that the Emergency Management Act is actually the statute that gives her the authority to do things, whereas the 1945 law is just something that is like a guiding post. Hey guys, go this way. This way to your Emergency Management Act powers that are, delineated in statute in the specifics. Okay? Let's see. Now the governor, of course, claims that the Emergency Powers of Governor Act gives her separate authority for emergency powers and that the 28-day time limit from the Emergency Management Act doesn't apply, but that's a whole different story and it's not even remotely true. There's no legal basis for saying that. Okay, so even our own governor right now, who's writing these orders and claiming that the 1945 law is what gives her the authority, she knew better in 2019. So keep that in mind. Okay, so then if we look at the Emergency Management Act of 1976, the one that will still remain on the books even if you sign that petition to put the issue in front of the legislature, the 1976 statute will still be on the books. In that statute, we have MCL 30.405, which gives additional powers to the governor. Let's see here. So some of them make sense and are understandable. It talks about basically being able to reorganize things within the executive branch in a shortened time frame so that she can utilize resources and get them out to people. That makes sense. But she can, under this 1976 law, not the one being repealed, but the 1976 law, the governor can commandeer or utilize private property necessary to cope with the disaster or emergency. Are you okay with the government taking your property because the governor, in her sole discretion, thinks that it's necessary in combating COVID-19 or what other thing might be going on at the time? I'm not. She can also direct and compel the evacuation of an entire area. Make you leave your business, make you leave your home, make you have to stay away from your church or what other, all the other things that we've come to know as things that she'll take away from us if she thinks she can. Under the 1976 statute, she can. It's not constitutional, but that I'll discuss in the next video as an update to the case that the legislature has against the governor. But the law itself, she can take your property, commandeer it, if she thinks it's necessary, and she can compel you to leave an area and stay away from an area. She can control the ingress and egress to an entire area, physically remove you from the area she has declared as the state of disaster or state of emergency. It says right here, she can physically remove your body from wherever she has deemed as necessary to do so. Under the 1976 law that they're leaving on the books. She can limit the sale, dispensing, or transportation of alcohol, explosives, and combustibles. Would ammunition be a part of that? What do you think, Second Amendment fans? Do you want her to be able to, under the 1976 law, be able to prohibit the sale of firearms or ammunition? Provide for the availability and use of temporary emergency housing. So we have to combine that with a bunch of other provisions, including the one about commandeering your home, because there is another statute in here, in the Emergency Management Act of 1976, that says that she can decide to take your home or your property or your business and turn it into a shelter for people, set up temporary housing there. That's the one that's not being touched by the legislature or this repeal act. I just want to be clear about that. That would be left alone. It is addressed through the constitutional amendment that I've been talking about, but not through the repeal. Then it says she can direct all other actions which are necessary and appropriate under the circumstances. Wow, she has blanket authority to do whatever she thinks is necessary. Meaning everything that she's done so far, she thinks is necessary, so she can continue to do that under the 1976 Act that they are leaving on the books. And this that I've been reading from is MCL 30.405, but you really got to dig into all the rest of it as well. Okay, so there is a provision, though, of the statute I was reading that does talk about they can't authorize the seizure, taking, or confiscation. So they can't take lawfully possessed firearms or ammunition. But what it does allow them to do is prohibit you from purchasing or transporting firearms or ammunition. And of course, it says here that a person who willfully disobeys or interferes with the implementation of a rule that an unelected commission creates, or a rule that the governor dictates without the help of the legislature in making that rule. If you disobey a rule, an order, or a directive issued by the governor pursuant to this section, you're guilty of a misdemeanor. So if you don't want her to take your home and make you leave so that she can use it as temporary housing for people, or she just doesn't, she thinks it's necessary to have your home be headquarters for some sort of operations to deal with the emergency or state of disaster, if you try to fight that in any way, it's a misdemeanor. In the 1976 law, that's being left alone. But that's just one piece to the puzzle. Okay, so we have the heightened state of alert, which is 30.421, MCL 30.421, and it gives additional powers to the governor. I was trying to find the highlights of this. That one can last for 60 days. The Emergency Management Act of 1976 that we know and love in Section 403 requires the state of emergency or state of disaster to be terminated in 28 days. However, if she declares a heightened state of alert, according to MCL 30.421, she has up to 60 days to do what she wants. That's one of them that they're leaving alone. They're not trying to repeal that act at all. And so, of course, that statute says that you're guilty of a misdemeanor. You could serve up to 90 days in jail, a fine of $100, or both. Yeah, so that's that one. These are all part of the Emergency Management Act that's being left alone. Let's see. There's also 30.411. I was looking to see if any, I don't think that one relates to so much of what I'm saying here. Oh, I must not have printed the other ones that I was going to reference for you today. Oh, here we go. MCL 30.406. This is the Emergency Management Act of 1976 that is not being repealed. MCL 30.406. All persons within this state shall conduct themselves and manage their affairs and property in ways that will reasonably assist and not unreasonably detract from the ability of the state and the public to cope with the effects of a disaster or emergency. So if you don't go overboard in following the governor's requests to a T, you could be classified as not reasonably assisting her, and therefore, by the way, this obligation includes appropriate personal service and the use and restriction of the use of property in a time of disaster or an emergency. So it spells right out, they can make you do things to serve her, the government, or whomever she directs. They can make you use your property in a way or not use your property in a way, however they seem to deem fit. And if you don't comply with all of that, well then, of course, it's a misdemeanor. This is in the 1976 law. Also, compensation for services or for the taking or use of property shall be paid only if obligations recognized herein are exceeded in a particular case, and only if the claimant has not volunteered his or her services or property without compensation. So they make it a huge hurdle for you as the person who is being forced to provide services, or who is being forced to allow the government to commandeer your property. You have a burden to show all of these things before the government even has to attempt to pay you compensation for that. That's in the 1976 law that no one's trying to repeal. Except the constitutional amendment that I'm putting forth is definitely, it definitely addresses that, but I don't want to spend time on that. We'll do that in a different video. Okay, so I could go on. Those are just some of the ways that things are going to be left on the books to harm us. So, like I said, I'm not saying you can't sign the 1945 repeal petition. You can sign that. And getting rid of that, you know, off the top of my head, I don't know that it's necessarily going to harm anything. What I'm asking you to keep in mind is that the 1945 Act, when that goes away, that doesn't solve the problem. All of the executive orders that have been issued to date based on the Emergency Management Act are still going to be around. All the additional super scary compensation issue topics, or commandeering of homes, or forcing you to provide personal service, forcing you to bend over backwards to follow the directives of the governor in a time of emergency or disaster, that will all still be on the books. In addition to some really special statutes. I mean, we have a lot of problems on the books. Ladies and gentlemen, the emergency management powers are nothing compared to all the other things that are out there. This is just something that brought it to the forefront of our minds, where we can actually start having discussions and debates about these topics. But it is by no stretch the only thing that's at, threatening our liberties. So we have two pieces of the Public Health Code in Chapter 333 that deal with basically allowing a local health officer to issue orders to prohibit the gathering of people, or to establish procedures to be followed by people. Basically, that your local health department can do exactly what the governor is doing right now under the Emergency Management Act, or the Emergency Powers of Governor Act, under the Public Health Code, which they're also not trying to repeal. Your local health department can order you to not gather, can order you to follow certain procedures for your lives, just the same as we have right now. Let's see. Would you be able to log on to my live feed and see if there's any questions that are coming up I can answer? Okay. Let's see. That was MCL 333.2453. 0.2453. That's the one I was just talking about. Then we have MCL 333.5207. That is in the that's just in the Public Health Code. And that is where there does not have to be a declared state of emergency involved, but the circuit court can order the department representative, your local health, your DHS office, a peace officer, to take an individual whom the court has only reasonable cause to believe is a carrier of what it doesn't say, is a carrier, into custody and transport the individual to an appropriate emergency care or treatment facility for observation, examination, testing, diagnosis, and treatment. They can pick you up off the street if they think that you might be a carrier of whatever. They can pick you up, detain you, and observation, examination, keep you for observation, examination, testing, diagnosis, and treatment. And so if you are already institutionalized in a facility, it continues, the court may order the facility to detain you so that you're not allowed to leave. And it goes on and on and on. Oh, by the way, an order issued under this section may be issued in an ex parte proceeding upon an affidavit of the local health department. So the burden is I can't even point how low. The burden of proof is way down here. So they just have to say, we might have reason to believe that there's someone who might have some sort of a disease, and so we're going to ask you, judge, to issue an order to allow us to take them, lock them up, observe them, examine them, test them, diagnose them, and treat them. That's not just related to COVID-19, but it sure is applicable to COVID-19. And it doesn't have to be in a declared state of emergency. In fact, it says to protect the public health in an emergency, but it doesn't say that there's a declared state of emergency. In fact, Kent County courts did this, I want to say in April, that they issued a bunch of warrants basically for the arrest of unnamed individuals, people that they had yet to identify, because they just wanted to be able to have that warrant in their pocket. So if they saw you coughing on the street and decided that they thought you were a threat to the public safety, they could go and take you and lock you up. That is in the Public Health Code. That statute is 333.5207, and the other one I mentioned 5 minutes ago, 333.2453. Those are not being touched by the repeal of the 1945 Act. They are directly hampered, lessened, for all intents and purposes removed with the passage of the constitutional amendment that we have going with the Restore Freedom Initiative. Okay, so I believe that covers like the basics of what the differences are and whatnot between the three petitions. Of course, here's the thing. They all go in the same general direction, right? We have the constitutional amendment petition. We have the recall petitions for the governor. We have the repeal of the 1945 Act. You can sign all of those. And all of them go in the same general direction on fixing the problem. But they do different things, and it just depends on what your primary focus or concern is in addressing this problem. Do you want to fix it long term so that this doesn't happen again? Do you want to simply remove the governor from office so she is punished and you can set an example of her? Or do you want to just take away the one piece of argument that she has right now, that 1945 Act, because you think all the other ones are too pie in the sky? There's three different objectives, all going in the same direction. You can support all three. There's no reason that you have to say one, only support one and not the other. I mean, you can personally choose to support one and not the other, but they can all work together.
Two questions. One, how did the health department get this power? The second is, didn't we requiring citizens to give up their personal property?
Okay, hold on that question then. Let me answer the first one. Okay, so the first question was, how did the health department get this power? Because the legislature wrote it into a bill. Scratch that. The Legislative Council physically typed out the bills, told the legislators what it says and whether they should vote on it or not. The legislature then voted on it, and the then governor signed it into law. One of the reasons why my constitutional amendment petition takes away the Legislative Council so that those things don't happen again. It also addresses this in a wide variety of other ways. But they got that power, the health department got that power from the legislature and from the governor.
Second one, when we revolted with the British government, wasn't requiring citizens to give up their property, and something we did to get rid of the British back in the day.
Yeah, so the next question is about, okay, when we had our whole American Revolution, when we declared our independence, weren't part of the things that we were protecting was the ability of us to keep our own property, not be forced into indentured servitude or whatever, that we had basically economic freedom. Yes. And that is what is guaranteed to us in the U.S. Constitution and the state constitution. When we say we're not supposed to be deprived of life, liberty, or property without due process of law, that is exactly what they were getting at. And there's also a takings clause. But so with the due process clause, though, what does that mean? Clearly, our governments have local and national and state. They've all trained us to believe that due process of law looks differently when you're trying to take someone's life, liberty, or property in the criminal context, from, say, the child protection context, from, say, the business licensing context. Why? Where does it say in the Constitution that it's supposed to be divided into all these various different forms, that every single kind of due process gets to be different as to however the government decides it to be at that moment? This constitutional amendment petition, the Restore Freedom Initiative, says, no, we're going to scratch that. We are going to make it so that all rights to which we are entitled, to which we were given by God, and our U.S. and Michigan constitutions cement and protect those rights. If the government wants to take away our right to life, liberty, or property, they have to prove beyond a reasonable doubt that doing so is necessary because we are actually taking away the life, liberty, or property of another person. They have to prove that beyond a reasonable doubt, and not just in criminal cases. Because why should the government get a pass, get to hit the Staples easy button on taking away any of our liberties? They shouldn't. And anyone who's going to argue with me against that, I'd love to do that. Let's do it on the Capitol steps. Apparently I'm comfortable there now. Let's go and have a debate on the Capitol steps as to why the government should be allowed to deny you of your life, liberty, or property with a lesser burden of proof than what is required in our criminal cases at this point.
When did the health department get that power?
When? Oh boy. So the question is, when did the health department get the powers to do what we were just talking about? One of them was talking about powers that were given to them in 1978. And the other one initially was enacted in 1988, but then it was amended in 1998. So 78, 88, and 98. That's how long those have been on the books. And the legislature didn't seem to mind this whole time that they were there. Anything else?
Questions?
No more? Sweet. Okay, so if you do have any more questions about this, let me know. Oh, this video is already longer than I wanted it to be. Please try to share this. Share this video. Share the video I did this morning on the petition update. Definitely share this video. Share it like wildfire to everyone with all these petitions because we can all work together. We can all work together. The other pieces to the puzzle are there. That's part of the same puzzle. We could do the recall stuff. We could do the Repealing 1945 Act. My only point is to make sure you are fully aware when you are fully engaged in supporting a certain petition that you know what it entails and what it does not entail. So let's share this so that we can all understand that we can work together. There's not a reason why we don't, why we can't. Okay? All right, guys, thank you so much. And if I have time in the next 4 minutes, I'm going to try to do a super quick update on the case with the legislature that they have against the governor. I'll log right off this live video and log right back in. Thanks, guys.